everybody. This one is about do-it-yourself Kangaroo Courts number 6, selling you into slavery, and how that works. Well, first of all, Kangaroo Courts are everywhere. The Kangaroo Court is a term descriptive of a sham legal proceeding in which a person's rights are totally disregarded, in which the result is a foregone conclusion because of the bias of the court or other tribunal. And so then we'll go through what the other parts of these. There was part 1, and it talked about all courts, the 2 general kinds, the 3 types of jurisdiction, what Kangaroo Court is, why they're holding a Kangaroo Court, why they want you to have a liar, and how to tell it's a Kangaroo Court, and what they do in a Kangaroo Court, and why they're Satanists. It's a satanic commercial transaction. And then in part 2, we talked about how to tell it's a Kangaroo Court and what they do in a Kangaroo Court. And then we got into some new material when we talked about what's been done by others to defeat their Kangaroo Court without going in there, and some things to do if they drag you in there. And then in part 3, we talked about why they want you to plea bargain and what happens if you do enter into a plea bargain. And I would never plea bargain. And then part 4, how it's a Roman cult commercial warfare, how it's a contract, and where's the contract, and where's the benefit I'm supposed to have taken advantage of that subjects me to this, and how we should admit nothing and make them prove everything and object to everything and reject their contract at allocution. And then in part 5, we talked about the object to testifying by the liars. It's an Admiralty proceeding, and the so-called judge is a clerk masquerading as a judge. The clerk is sitting there playing stupid, and if you do not object, then the bail priest will accept it as true, and you won't create appealable issues in the transcript, because the transcript, if there's no appealable issues in the transcript, it's the transcript that the Court of Appeals is going to go by. And then this one is part 6. All courts, the United Nations courts operating under UNIDROIT. UNIDROIT is law merchant and the Uniform Commercial Code, and there's no common law because of martial law, and there's martial law because of the bankruptcies, because of the military occupations that are going on in various locations, and because there's no money. Judges are bought and paid for clerks, and they collect a royalty, and they sell you into slavery to populate the prisons. And that's actually found in the Uniform Commercial Code, and we'll get into that. Anyways, UNIDROIT stands for the Unification of Private Law, and the website says that 63 countries have adopted it, and it's designed to be automatically implemented. So the same thing is any of these 63 countries can use this material to show that that this is what they're doing, okay? Because this all falls under the Uniform Commercial Code and UNIDROIT, okay? Canada and the United States have been signatories to the UNIDROIT Treaty for over 30 years. UNIDROIT website says it's designed to be automatically implemented. In other words, UNIDROIT makes a change, all of the signatories to the treaty are required to make the same changes, okay? And so this UNIDROIT, this is over the whole world. This is their website, and this is talking about they have jurisdiction over commercial contracts, cultural property, franchising. And this gets in closer. And then there's more stuff. They talk about leasing, security interests, transport, banking law, capital markets, civil procedure, contracts in general, cultural property, franchising, hotel keepers, insurance, intellectual property, leasing, legal status of women, maintenance obligations, movement of persons, and negotiable instruments. Okay, all of this falls under Roman law, by the way. So it covers mandatory insurance for motor vehicles, anything related to marriage, divorce, and children. And this is actually taken off their UNIDROIT website. And it talks about the 1955 Benelux Treaty on compulsory insurance against civil liability in respect of motor vehicles. and the 1958 Convention concerning the recognition and enforcement of decisions relating to maintenance obligations towards children, and that's the Hague Conference on Private International Law, and then the 1959 European Convention on Compulsory Insurance Against Civil Liability in respect of motor vehicles. Okay, so this is all the UN. Anyways, this is the partial list of the countries. I don't have the whole list here, but I want to show that Canada, Australia, there's a bunch of countries that are signed on to this treaty. And here, this page shows United Kingdom, United States, South American countries, a lot of countries, 63 countries. I would suggest you go to the website and you can do a search at Google. Anyways, all of this stuff is actually found in the International Covenant on Civil and Political Rights, Article 2, Clause 1, or a lot of it. Let me put it that way. A lot of it, especially the stuff with that brings the courts under UNIDROIT, although they're already they all operate under UNIDROIT anyways. But anyways, it just reaffirms it under the International Covenant on Civil and Political Rights. This is Article 2, Clause 1. Each state party to the present covenant undertakes to respect and ensure to all individuals within its territory and subject to its jurisdiction the rights recognized in the present covenant without distinction of any kind such as race, color, sex, language, religion, political or other opinion, national, social origin, property, birth, or other status. Now, and one of the things I want to mention is none of this is supposed to apply internally. Because the treaty power is not meant to be used internally. I've got another video about that. And so that's really the argument to defeat it. But the bottom line is all these courts are UNIDROIT courts. Okay, so you go into the court, well, you're going into the UN is what you're doing. And any of these courts are all operating under UNIDROIT, okay? And so they send their pig thugs out to assault you, and then the only remedy is to go to the UN to get a remedy. And so that's all part of the plan. That's all part of the plan. Anyways, this is Article 2, Clause 2. Were not already provided for by existing legislation, legislative or other measures, each state party to the present covenant undertakes to take the necessary steps in accordance with its constitutional processes and with the provisions of the present covenant to adopt such laws or other measures as may be necessary to give effect to the rights recognized in the present covenant. And so they're all agreeing to adopt laws, right? This is Article 2, Clause 3. Each state party to the present covenant undertakes to ensure that any persons whose rights or freedoms as herein recognized are violated shall have an effective remedy, notwithstanding that the violation has been committed by persons acting in an official capacity. B, to ensure that any person claiming such a remedy shall have his right thereto determined by a competent judicial, administrative, or legislative authorities, or by any other competent authority provided for by legal system of the state, and to develop the possibilities of judicial remedy. And C, to ensure that the competent authority shall enforce such remedies when granted. And so, I mean, all these courts fall under UNIDROIT, under the UN. The state parties to the present covenant undertake to ensure the equal rights of men and women to the enjoyment of all civil and political rights as set forth in the present covenant. And then this is Article 16. Oh, that was Article 3. This is Article 16. Everyone shall have the right to recognition everywhere as a person before the law. So, again, they drag you in there, and then they assault you with this person. That's exactly what they do. These people are Satanists. And these advertisements, I put them in places because I want to make sure that it gives me a chance to cool off. So if I get really going, I have an advertisement that I can cool off with. Anyways, don't forget to subscribe to this channel, and don't forget to click on the bell next to the subscribe button so that you're notified when there's a new upload. This is an image of my channel, and the subscribe button is on the right hand side of the page there with the arrow, and the arrow's actually pointing at the bell. When you click on that bell, you will then you'll be notified of all the uploads. Okay, so the little pop-up will come up and ask if you want to be notified about all the notifications, and the answer is yes to that, by the way. I mean, that's assuming you want to be notified. And so, yeah, but the bell will send you, once you do that, you'll get noticed of all the uploads when I send an upload. Anyways, back to the topic at hand. This is the law of customs, law and customs of war on land. This is Hague Convention 4, Article 42. Territories considered occupied, and so the previous part we were talking about UNIDROIT. Now we're going to talk about the military occupations because many countries are under military occupation. I would say probably 3/4 of Canada is under military occupation. I'd say at least half of the United States is under military occupation, maybe even 2/3 of it's under military occupation of, actually more like about, you could actually show that about 80% of it is under military occupation. Anyways, of the United States, and I'll bet you the same. Australia is all under military occupation. And so the British Crown has gone and occupied most countries, or any country that they've been in. You could probably show the military occupation. And so military occupation is important. It goes to the martial law, and so and the Uniform Commercial Code. Anyways, territory is considered occupied when it's actually placed under authority of the hostile army. The occupation extends only to the territory where such authority has been established and can be exercised. And this is Article 2 of the Geneva Convention relative to the protection of civilians in a time of war of 1949. In addition to the provisions which shall be implemented in peacetime, the present convention shall apply to all cases of declared war or of any other armed conflict which may arise between two or more high contracting parties, even if the state of war is not recognized by one of them. Okay, so this applies to any armed conflict, even if one of the parties doesn't recognize the state of war. In other words, they don't even know that such a thing exists. Okay, and these Satanists like to do that kind of thing. Okay, anyways, the convention shall also apply to all cases of partial or total occupation of the territory of a high contracting party, even if the said occupation meets with no armed resistance. And you would think that if the state of war is not recognized, then there probably wasn't any armed resistance. Okay, anyways, although one of the parties in conflict may not be a party to the present convention, the powers who are parties thereto shall remain bound by it in their mutual relations. They shall furthermore be bound by the convention in relation to said power if the latter accepts and applies the provisions. So all the parties that are a party to this Geneva Convention relative to the protection of civilians in a time of war are saying that they're bound by it, whether even if one of the other parties not involved in it. Anyways, it not signed on. In other words, all of the like the Western United States, anything west of the original 13 colonies is under military occupation. You can show that, or I can show that. And so therefore, and the First Nations people aren't parties to this contract. And so therefore, but it's saying that the United States is still bound by this contract, even though the First Nations people and the First Nations land is all under military occupation. And same thing in Canada. Anyways, to keep going here, this is Article 1 of the Liber Code. A place, district, or country occupied by an enemy stands in consequence of the occupation under the martial law, the invading or occupying army, whether by any proclamation or declaring martial law or any public warning to the inhabitants has been issued or not. You know, quite frankly, no occupying army is going to ever say, okay, you guys, we got you under martial law. You know, everybody would rise up in rebellion. And so they're not ever going to say it. If the people are too stupid to figure that out, then too bad. You get to be a slave. Okay? Think about it. Martial law is the immediate and direct effect and consequence of occupation or conquest. The presence of the hostile army proclaims its martial law. And so just their physical presence is proof that it's under martial law. Article 2 of the Liber Code says martial law does not cease during the hostile occupation except by special proclamation ordered by the Commander-in-Chief or by special mention in the Treaty of Peace concluding the war. And so I haven't ever seen a special proclamation in Canada and the United States anyways, ending the martial law. And I've seen a bunch of treaties of peace, and I don't remember seeing anything about ending the martial law. Anyways, I'm going to have to go and look at the Treaty of Peace of 1783 the U.S. signed with England. But certainly, like the Treaty of Hidalgo, doesn't say anything. I've read that one, and it doesn't say anything about ending martial law. When the occupation of a place or territory continues beyond the conclusion of peace as one of the conditions of the same. So, in other words, it's got to be in special mention in the Treaty of Peace concluding the war. Otherwise, the military, the martial law is going to continue beyond the Treaty of Peace. That's what it's saying here. Anyways, and this is non-ratification of the 14th Amendment by Judge A.H. Eller to the Utah Supreme Court. And what he does is he's got about a 150-page book actually and this is associated with the case D.I.Y versus Turner. Anyways, he has the entire Libre Code in there, and he makes comments in between each section and talks about them. This is actually a comment that was in Article 3 of the Libre Code, and it's relevant because it shows what's going on. It says, note, under the law martial, only the criminal jurisdiction of a military court is the recognized law, but as Article 3 says, the civil courts can continue wholly or in part as long as the civil jurisdiction does not violate the military orders laid down by the Commander-in-Chief or one of his commanders. By this means, a military venue, jurisdiction, and authority are imposed upon the occupied populace under disguise of the ordinary civil courts, and officers of the occupied district or region, because the so-called civil authorities are in an occupied district or region, only act at the pleasure of a military authority. And it should also be noted here that the several state legislatures, county boards of commissioners, and city councils are constantly legislating to please the edicts of the federal government, the occupying force, and that their legislation in this sense is not an exercise of state sovereignty, but instead a compliance with the edicts of the military force which occupies the several states and consequently are edicts of martial law rule. And so, you know, you can see that happening like in Canada, okay? All of the Alberta, British Columbia, Saskatchewan, Manitoba. I mean, they say that they got these provinces are set up so that they're states under the BNA Act, and they're not. Okay, those are basically extensions of the federal government in Canada because of the martial law. It's all a big charade. They just put on a charade. It's a fraud. You know, that's exactly what goes on. And the same thing in the states. You know, Texas is under military occupation. All Texas statutes are really D.C. statutes. That's exactly what they are. Anyways, and this has been going on from the beginning of time, okay? This is talking about the bankruptcies, okay? So remember we talked about the military occupations. Now we're going to talk about the bankruptcies, and then we'll talk about the money, okay? Because there's no money. We will establish a perpetual obligation and concession. We will establish that from the proper and especial revenues of our aforesaid kingdom, for all the service and customs which we ought to render for them, saving in all things the penny of St. Peter, the Roman Church shall receive yearly 1,000 marks sterling, namely at the feast of St. Michael 500 marks, and at Easter 500 marks. And then they say that 700 marks for the Kingdom of England and 300 for the Kingdom of Ireland. And so, and this is the concessions to the Pope, 1213. Okay, this is when England went bankrupt. Okay, and they're owned and operated by the Roman cult under this concessions to the Pope, 1213. And this is U.S. Senate report. This explains it much better. This document and the next one we're going to talk about. This one is U.S. Senate Report number 93-549, dated November 19th, 1973. Anyways, it says since March 9th, notice the date, Since March 9th, 1933, the United States has been in a state of declared national emergency. Under the powers delegated by these statutes, the President may seize property, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communication, regulate the operation of private enterprise, restrict travel, and in a plethora of particular ways, control the lives of all American citizens. A majority of the people of the United States have lived all their lives under emergency rule. That's martial law rule. For 40 years, freedoms and governmental procedures guaranteed by the Constitution have in varying degrees been abridged by laws brought into force by states of national emergency. So, martial law rule is an emergency rule. And so, anyways, and then notice March 9th, 1933, we'll get a load of this. This is the U.S. Congressional Record, March 17th, 1993, and it's the same date. It says here, it's an established fact that the United States federal government has been dissolved by the Emergency Banking Act, March 9th, 1933. See, it's the same date that when it went under emergency rule, and that's the same date that the government went bankrupt. And so, and that's located at 48 Stat 1, Public Law 89-719, declared by President Roosevelt being bankrupt and insolvent. HJR 192, 73rd Congress in session, June 5th, 1933. Joint resolution to suspend the gold standard and abrogate the gold clause, dissolve the sovereign authority of the United States in the official capacities of all United States governmental officers, and departments, and is further evidence that the United States federal government exists today in name only. And so the point being is that March 9th, 1933 is when all of that began, and March 9th, 1933 is when everything went under martial law. And that's everything in the United States. Of course, technically, it's District of Columbia and the territories. But what happens is all these states that are under military occupation are now territories, okay? And so it all falls under emergency rule. But you also have to understand that if you're not a U.S. citizen, then none of it really applies. But again, it goes back to the courts, because the courts are all UN courts. They're bought and paid for whores selling their justice, and you don't get justice in there because of that. And so that's where it all goes to. So they send their pig thugs out to assault you, give them a gun, hire low intelligence ones because they want to make sure that they don't have two brain cells. They want to make sure they go out and assault lots of people. And you see it every night on TV where they're murdering somebody, and send them out and tell them to go and do that stuff. And then the only remedy is in the Kangaroo Courts. Anyways, don't get me going. And then the money. At common law, only gold or silver are legal tender. And so the presumption is that there's no money. And that's part of the martial law rule. And if there's nothing is paid for, then if you want lawful government, you have to have lawful measures. Again, the fact that there's no money brings it all into the matrix. And then it goes further, okay? There's no common law. It eliminates common law. There's no common law crimes in the United States. These are U.S. versus Hudson and Goodwin, 1812, United States versus Coolidge, U.S. versus Britain, United States versus Eaton. I mean, there's a bunch of court cases that talk about it. There's no common law offenses against the United States, only those acts which Congress has forbidden with penalties. Remember, we're going to talk about that here in a little bit, about penal and penalties for disobedience of its command are crimes. And the same thing in Texas, okay? Because Texas is under a military occupation, so it would make sense for Texas. Under Texas law, no act or omission is a crime unless made so by statute. The legislature may create an offense in the same enactment, provide exceptions to its application. Everything is an admiralty. And no common law crimes. This is Tomlin's Law Dictionary, 1835 edition. A writ of error doth not lie upon a sentence in admiralty, but an appeal, okay? And so in these courts, it's always a sentence, okay? And all sentences are taken in admiralty. And the only way you can get a remedy from that is by an appeal, okay? And it's all courts of appeal. And in Canada, the Supreme Court of Alberta, what was once the Supreme Court, is now a court of appeals. And in the states, each state has its own Supreme Court, but there's courts of appeals. There's a whole network of courts. You know, all these whores are getting in on it. But this is citing in Book 4 of Institutes and the Laws of England by Coke. Okay, so this is as old as time itself. This is nothing new. All appeals are in admiralty. That's why it's called a court of appeals. It is the same thing. This is the same thing that precipitated the War of Independence. And this is the causes and necessities for taking up arms, 1775. Statutes have been passed extending the courts of admiralty and vice-admiralty far beyond their ancient limits for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law and instead thereof to publish an order in use and exercise of the law martial. And for altering fundamentally the form of government established by charter, we saw the misery to which such despotism would reduce us, okay? It's a tyranny, okay? It's a tyranny. It's a dictatorship. It's a despot, okay? This is satanic. This is all Roman cult. They get rid of common law. Common law is God's laws found in the Bible. We've talked about that. Christian government in some of my other videos. And they just get rid of that little common law problem, and now they can impose martial law. It's all satanic, okay? Anyways, and this is D.I.Y. This is the non-ratification of the 14th Amendment by Judge A.H. Ellett by the Utah Supreme Court. It's associated with the case D.I.Y. versus Turner, and this explains the same thing in a little bit different way. Anyways, in the meantime, civil law was the form of law imposed in the Roman Empire, which was largely, if not wholly, governed by martial law rule. Equity has always been understood to follow the law. To have superior equity is to turn things on their head. This is exactly what happens when martial law is imposed. If equity is the law, then it follows its own course rather than following the common law, thereby destroying the common law and leaving what is called equity in its place. And so, yes, normally when it's not under martial law, okay, then equity follows common law. And so, and the scriptures, the Bible actually talks about equity. But what happens is that when martial law is imposed, it eliminates common law. And so equity doesn't have anything to follow. It can do literally anything it wants, and they even have statutes that talk about that, where the courts of equity can do anything they want. And it's 100% correct. And so it destroys the common law. When the martial law is there, it destroys the common law and leaves what's called equity in its place, which is basically a bunch of Baal priests doing whatever they feel like doing. Now, and this is the Declaration of Independence, for abolishing the free system of English laws in a neighboring province, establishing therein an arbitrary government, military dictatorship, and enlarging its boundaries so as to render it at once an example and instrument for introducing the same absolute rule into these colonies. He is, and now you got to understand what the Declaration of Independence is. It's basically a list of grievances. Anyways, he's abdicated government here by declaring out of his protection and waging war against us for protecting them by a mock trial. Okay, this is all martial law. Okay, no common law, martial law. And this is again the non-ratification of the 14th Amendment by Judge A.H. Ellett, the Utah Supreme Court, associated with the case D.I.Y. versus Turner. Congress claiming its martial law power to declare war, suppress insurrections, and repel invasions, imposed martial law on the United States and never discontinued it. The result was an extension of the military and municipal jurisdiction of Congress. But where's the evidence of this? Look at the 13th Amendment, the Civil Rights Acts, the legal tender laws, the 14th Amendment, etc., etc., etc. And that same non-ratification of the 14th Amendment goes on. It says the 14th Amendment is an extension of national military powers presently used in a municipal character and enforced by municipal laws stretched far beyond their original limitations and enforced by Article 1 tribunals, okay? Kangaroo Courts, okay? And the same thing's going on in Canada. This is a social insurance number instruction sheet application form, and it says you got to pay $10, and you send it to the Receiver General for Canada. So Canada's bankrupt, and so the same thing's going on in Canada, and with a little bit of research, it wouldn't be hard to prove it in any country, almost any country. And so watch the bankrupt corporate so-called governments video. That's why they make statutes for common law crimes like murder, assault, theft, etc. That's why they make statutes to protect common law rights. The courts have ruled that common law rights, that our rights are unlimited, and that no statute is required for our rights. It's common law. But they have to make statutes because there is no common law, okay? They've gotten rid of common law, and so they basically are converting our rights into legislative privileges, and that non-ratification of the 14th Amendment even talks about it that way. And now, back to another advertisement, announcing a subscription-based YouTube channel called Sovereignty International. The recommended cost of the subscription is currently $1.99 a month because it avoids the advertising only. Originally, when I set up this channel, I was going to have some exclusive material, but then after thinking about it, I thought, that the only power that these New World Order Satanists have over us is through fraud and deception, and my agenda is to expose it all for everybody's benefit. And so I can't think of anything that I want that I wouldn't want to have available freely to everybody. So the only advantage, I'm not saying I won't have exclusive material, but I can't say that I can have anything in mind to put on there exclusively. So at this point, there might be some exclusive material at some point, but right now there's not. And the only advantage is you avoid the advertising, and it's a great way to make a donation if you want to make a donation too. And a little bit from a lot of people makes a lot of difference. So anyways, I'm currently publishing 6 videos a week. Some of the people have said they can't find the channel, and so I've got a link down here at the bottom that you can go and find it on YouTube. And also, this is the YouTube channel, and at the top is the link to the channel. And on the side, what happened is some people sent me $1.99, and thank you very much. But I was concerned that that they were looking for me to sign them up, and I can't do that. They have to do it. I sent them an email, but they haven't responded. Anyways, they have to go through this start free trial. I have no control over signing anybody up. I may be able to remove people if they want to be removed, but I certainly cannot sign anybody up. It has to go through YouTube. They probably have to make payment arrangements, and YouTube wants to probably take their piece of the action. And so I have no control over that. And so you're going to have to go to, you're going to have to do it that way. I have no control. Okay, so, and now it comes to the liars, okay? They always want to assault you with one of their liars. And all bar members, he is, however, in a sense, an officer of the state with an obligation to the court. That's found at Book 7 of the Corpus Juris Secundum, Section 4 on attorneys. His first duty is to the courts and to the public, and not to the client. And whenever his duties to his client conflict with those as an officer of the court in the administration of justice, the former must yield to the latter. So these liars, that's why they're liars. Corpus Juris Secundum, Section 4, Book 7. And then clients are also called wards of the court. And a ward of the court is a infant, a person of unsound mind, imbeciles, okay? Their rights must be guarded jealously. Oh, yeah, right. They'll sell you down the river is what they do. A ward of the court's an imbecile. A ward of the court is not competent. Everything is about competence and incompetence. That's why they're representing you, because you're not competent to make decisions for yourself. Therefore, the attorney is going to make the decisions for you. There's no such thing as an incompetent sovereign. Do you know who you are? And so they're going to assault you and testify for you and do all sorts of stuff, okay? And if you don't recognize it, they'll sell you down the river. Anyways, a penal action, okay? And remember, we talked about that in the beginning, okay? Talked about penalty, okay? A penal action is an action on a penal statute, an action for recovery of penalty given by statute, where an action is founded entirely upon a statute, and the only object is to recover a penalty of or forfeiture. Such action is a penal action. Okay, so penal, penalty, it all goes together, and offense. Okay, the words penal and penalty in their strict and primary sense denote a punishment, whether corporal or pecuniary. Okay, and so pecuniary is the same kind of word, right? Imposed and enforced by the state for a crime or offense against its laws. The noun penalty is defined forfeiture or to be forfeited for non-compliance with an agreement. Okay, it's a contract. They have to assault you with one of these contracts. The words forfeit and penalty are substantially synonymous. That's why it falls under the Uniform Commercial Code. This is all commerce. It's all business. And this next site, a penal action is one founded entirely on statute and brought for the sole object of recovering a penalty or forfeiture imposed as punishment for a specific offense, while remedial action is one brought to obtain compensation or indemnity. A penal action is one founded entirely on statute, and the only object is to recover a penalty or forfeiture imposed as a punishment for a certain specific offense, while a remedial action is one which is brought to obtain compensation or indemnity. A penal action is a civil suit brought for the recovery of a statutory forfeiture when inflicted as punishment for an offense against the public. Okay, so all offenses are penal. Okay, such actions are civil actions on the one hand, closely related to criminal prosecutions, on the other, for actions for private injuries in which the party aggrieved may by statute recover punitive damages. Okay, so this only applies to the slaves, is what it comes down to. This is all why it all falls under the Uniform Commercial Code. They assault you with one of their contracts, and we're going to show you here right in the Uniform Commercial Code how they do it in a couple minutes. Anyways, they assault you with this contract. An offense has to do, offense and penal is all, they work together. And they're just nothing but a bunch of, that was what I was going to say. When you ask, people have asked the Kangaroo Court, okay, the clerk masquerading as a judge, I'd like to know the nature of this proceeding. And when you nail him down, he'll finally come out and say that it's quasi-criminal. Well, see, again, they can't tell you the truth, okay? They're liars. That's what they do. They lie. Everything they do is a lie. And so, or half-truths, which that's a half-truth, okay? A penal action is a civil suit, okay? So they're not going to tell you it's a civil action, but that's exactly what it is. Anyways, another advertisement for great custom websites, domain names, and hosting. Go to cubeyard.com, and if you use coupon code CY172 for 20%, you get 20% off your first order. And so, go to cubeyard.com. So that's why, back to the topic at hand, that's why they want you to have one of their liars, okay? So then this liar can testify for you and make all sorts of conclusions at law and make sure and get you sold down the river, okay? And that's what they do. And the prosecutor represents you too. Okay, when you're in one of these kangaroo courts, the prosecutor's representing you. If you have a liar, he's representing you. They're all representing you. They're all getting in on the action. The judge is representing you. That's why they enter a plea for you. How do you think that they can enter a plea? It's by representing you. Allegations of legal conclusions cannot be permitted to supply essential allegations of fact. Now, the stuff in square brackets was added, so I'm not even going to talk about that, but that it further expands on what these legal conclusions were. But so allegations of legal conclusions cannot be permitted to supply essential allegations of fact. A mere conclusion of a pleader cannot be availed of to initiate and invite an issue of fact. Okay? An allegation of conclusion of law tenders no issue. Okay? So it's all a kangaroo court. These Satanists, that's what they do. Where there are no depositions, admissions, or affidavits, the court has no facts to rely on for summary determination. If the record does not show upon its face the facts necessary to give jurisdiction, they will presume not to have existed. And again, that's what they do. That's why these people are Satanists. A pleading cannot be aided by reason of facts not averred. Facts necessary to a cause of action but not alleged must be taken as having no existence, okay? And that's why they got to give you a lawyer so he can testify for you, okay? He can sell you down the river. Oh, gee, he's so sorry. Oh, my client is so sorry. The government of the Virgin Islands cannot assume facts not in evidence, even if the judge believes the facts to be accurate, okay? So the liar testifies. Remember, this is what this is talking about. This is a clerk masquerading as a judge. He's sitting there playing stupid. And if the liar testifies, and that makes any statement, whatever he says, okay, and you do not object, okay, the clerk masquerading as a judge will accept it as true, okay, and they'll sell you down the river. The Roman cult bar members will represent you whether you like it or not. If you do not object, the clerk masquerading as a judge will accept it as true. See the Do-It-Yourself Kangaroo Courts 5 testifying by the liars video. See the Do-It-Yourself Kangaroo Courts 1 and 2 that describe how and when a judge is dealing with a statute, he's a bought and paid for clerk masquerading as a judge. And now another advertisement. Bankster Thieves, check out my other videos. Bankster Thieves 1, 2, and 3, Churchianity Series, Bankrupt Corporate So-Called Governments, Bar Members 1, 2, and 3, Do-It-Yourself How Not to Volunteer for the Selective Service, Martial Laws here, Do-It-Yourself No Income Tax, Do-It-Yourself No Sales Tax, Do-It-Yourself Traffic Stop, Do-It-Yourself Free Mail, Do-It-Yourself Kangaroo Courts. And so check out my other videos if you want to know more. Back to the topic at hand. And this is the Uniform Commercial Code. This is Section 1-206. In Texas, it's called the Texas Business and Commerce Code. But you'll find this is pretty well consistent in every state. Whenever the uniform, and the reason it is consistent is because it's all coming from UNIDROIT. Whenever the Uniform Commercial Code, and that's in square brackets, notes, and so actually what it says is whenever this title, I think is what it says. Creates a presumption with respect to a fact or provides that a fact is presumed, the trier of fact must find the existence of the fact unless and until evidence is introduced that supports a finding of its non-existence. Okay? So they're talking about courts here. Okay? I mean, the trier of a fact must find the existence of the fact unless and until evidence is introduced that supports a finding of its non-existence. So this is all Uniform Commercial Code. That's why you have to defeat their presumptions. Okay? It automatically, there's presumptions that are made when that liar is testifying for you. When they just charge you with anything, then there's certain implications of the charge. Anyways, that's UCC 1-206. This is, this is actually Texas Business and Commerce Code, Section 3-3.308, which would be 3-308, proof of signatures and status as holder in due course. In an action with respect to an instrument, the authenticity thereof and authority to make each signature on the instrument are admitted unless specifically denied in the pleadings. Okay? Get a load of this. If the validity of a signature is denied in the pleadings, the burden of establishing the validity is on the person claiming the validity, but the signature is presumed to be authentic and authorized. Okay, so first of all, what they do. Okay, well, let's go. We'll talk about this next section. That's 3-308, and this is 8-114, and this is Texas Business and Commerce Code evidentiary rules regarding certificated securities. Okay, and so the following rules apply in an action on a certificated security against the issuer. Okay, if they forge your signature onto a contract, then you are the issuer. Unless specifically denied in the pleadings, each signature on a security certificate or in a necessary endorsement is admitted. If the effectiveness of a signature is put in issue, the burden of establishing effectiveness is on the party claiming under the signature, but the signature is presumed to be genuine and authorized. Okay, so what they do is these Roman cult Satanists forge your signature onto a contract and then presume it's authorized and authentic. And who's going to call a judge a liar? Even though he's not really a judge, he's a clerk. He's a bought and paid for a clerk. He's got the title. Okay, are you going to call a judge a liar? You better come up with some witnesses, because they'll just ignore you. Okay, that's how these Satanists work. Okay, that's how they're populating the prisons. Is they go and forge your signature onto a contract and then presume it's authorized and authentic, and you don't even know this contract exists, and how do you challenge something you don't even know is there? Carl Lentz brought up the issue of forgery against the CPS pigs when they stole his son in his successful one-page lawsuit. Okay, and he got his son back after 11 years, okay? They stole his newborn son, and he got his son back after 11 years. And that's what these Satanists do, okay? This is satanic. This is diabolically evil. These people are Satanists, and, we ought to see them hanging from some tree somewhere is what I would like. Common law. Of course, I'd give them due process. Okay, we could hold a common law trial for them and then dispatch them. So the judge works for the state. The prosecutor for the state works for the state. The police or witness works for the state. They are nothing but a bunch of thieves. The vast majority of the disputes that the police initiate on behalf of their employer are also adjudicated by their employer, where the plaintiff, the judge, the antagonist, the police, and the only witness, also the police, all represent the same party. And since no corpus delicti mens rea or acts reus can be produced, doesn't technically qualify to be heard according to its own laws. The state, therefore, is indistinguishable from a criminal cartel. Okay, and so they sit there and they will represent you. And they will sell you down the river, and they'll assault you with this so-called contract and sell you down the river. And unless you defeat their presumption, okay, the key is are you a U.S. citizen or not? Okay, it all comes down to being one of these, a person, okay, one of their slaves. That's really what it comes down to. Anyways, every taxpayer is assessed to K trust having sufficient interest in preventing abuse of the trust to be recognized in the field of this court's prerogative jurisdiction. A citizen of the United States is a civilly dead entity operating as co-trustee and co-beneficiary of the public charitable trust, the constructive Sestake Trust of U.S. Inc. under the 14th Amendment, which upholds the debt of the USA and U.S. Inc. And that's a summary of the congressional record dated June 13th, 1967, of the text that's found on page 15,641 through 15,646. And so this is all coming from the Roman cult. This is Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of mort main. Yet still it was found difficult to set bounds to ecclesiastical ingenuity, for when they were driven out of all their former holds, they devised a new method of conveyance by which the lands were granted not to themselves directly, but to nominal fiefs to the use of the religious houses. Okay, so this is all coming from the Roman cult, thus distinguishing between the possession and the use and receiving the actual profits. While the season of the land remained in the nominal fief, who was held by the courts of equity, then under the direction of the Roman cult, and still under the direction of the Roman cult, to be bound in conscience to account for, to assesticate use for the rents and emoluments of the estate. That's taxes And it's to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. And it's still the foundation of modern conveyancing. And they assault you with the sesticate trust and then steal your property and sell you into slavery. That's exactly what they do. So what you got to do is you got to make it so they don't want to talk to you. And you serve them with a watch the do-it-yourself estoppel certificates video. You have to put them in the position that they cannot talk to you. Okay, that's the only way you can do it. That's what an estoppel certificate is, or a document you serve on them that defeats their presumptions before they ever see you coming. And that's the only way, or the best way. I mean, you still might be able to do it. But that's the best way, is defeat it before you ever see them coming, because then if they look at you wrong, you file a criminal complaint, and the next thing you know, the guy has got his walking papers. File a notice of void judgment into the case is another alternative. Demand a trial by jury. Now, there aren't any trial by jury these days. They're all trial with jury. And most of the people out there that are populating these juries are idiots. So I'm not sure that you'll ever see any justice that way. But anyways, there's a lot of people trying to educate jurors. There's the Fully Informed Jurors Association, and so there's hopefully the people wake up to what's going on. These people are cowards, okay? They are Satanists. The pigs and their bosses are operating as criminal street gang. They're engaging in fraud to get you into one of their so-called contracts. Why do they lie? Because they're cowards. All liars are cowards. They're afraid to tell the truth. That's why it's all a fraud. They're nothing but Satanists. They're cowards. They're liars. They're afraid to tell you that they're perjuring their oath and assaulting you with their so-called contract. All liars are cowards. But if the watchmen see the sword come and blow not the trumpet, and the people be not warned that the sword come and take any person from among them, he's taken in his iniquity. But his blood will I require at the watchman's hands. Either you're part of the problem, you're part of the solution. You're now a watchman. Circulate this video far and wide. My next video is going to be on corporate denial affidavits, okay? All of their presumptions are based on the corporation, and so are the sesticate trusts. And so you have to defeat that. You do it up front. You record it so they can't. It becomes public policy after 30 days. It makes it very difficult for them to deal with. Copies of these documents can be found in my private group at Yahoo called Administrating Your Public Servants. I have YouTube videos that are videos of private information shares that show these and other court citations that are available for a donation. Donations to support this work are appreciated. This last paragraph is for all the Satanist order follower revenue officers operating in their private capacity under the Federal Tax Lien Act of 1966. They can take their privileges and benefits and put them up their rectal orifice. Donations to support this work are appreciated, but I prefer gold or silver coin. But as an extremely less desirable alternative, I can accept their commercial paper IOUs, their Federal Reserve notes, PayPal gifts, checks, money orders, etc. Send me an email for particulars. My blog is sovereigntyinternational.wordpress.com. My website is sovereigntyinternational.fyi. My email is engineerwin@yahoo. My YouTube profiles, I got two of them now, Sovereign Living and Sovereignty International. My community page, Facebook community page, I deleted it due to censorship on the part of Facebook. My private group on Facebook called Sovereignty International is being deleted. It's hard to ban 17,000 people off of that group. It takes time. And the reason is I'm not going to allow Facebook to make money off of my hard work. My Yahoo private group is called Administrating Your Public Servants. My Google private group is called Administrating Your Public Servants. I appreciate you watching the video. I hope you get something out of it. Now you know exactly what these Satanists are doing, and then we're going to talk about the corporate denial next, and how one of their biggest presumptions that they take, and how to defeat it. And that's coming up next. And I appreciate you watching the video, and spread the word, and have a great day.